Yeah, good evening, Umagaru. Yeah, thanks for joining the session.
Thank you,
So,
Ade.
yeah, no problem. So, yeah, Umagaru, as you know, right, about this proclamation brought a lot of questions to our community
Yes,
members. And,
yes,
so, yeah, yeah, we want to get your expert opinion or know like what is happening, the updates
sure.
on this. Uh, And
There's a
then,
lot of confusion that was initially, once the proclamation was signed by the president, a lot of confusion was created, but I think we can clear up things pretty easily. I've got more information uh, later this evening, Andy. So I will clear up whatever I've got the information. And I'm pretty sure in the coming days we may get more information also for some of the questions. We as attorneys also don't have answers to that. But let's start off with the proclamation for the 100,000 fee that was imposed on H-1B specialty occupational workers entry into the United States. Basically, that is what the proclamation is about. And they're charging an additional fee of 100,000 in addition to the USCIS fee that the employers were paying, which was ranging between 3,000 to 6,000, depending on whether it's premium or non-premium. So that was the fee, and that continues to be there. But the biggest questions that a lot of people have is um, giving examples. I'm going to tell you somebody is in the United States already on an H1, and for example, they're changing employers at this juncture. Do they have to pay the 100,000? The answer is no. Anybody who's in the United States, whether they are filing for an extension, filing for an amendment, filing for a change of employer, filing for any kind of extensions or amendment or change of employer, they don't have to. The other scenario that we also see quite often, Kishore Garu, with the present condition, a lot of people are losing jobs and they are going from H1 to B2 or an F1, and they now get a job with an employer who's willing to sponsor their H1. So the question comes up, does that particular individual have to pay the 100,000 because they're coming from a B2 to an H1 or an F1 to an H1? The answer is no. None of the applicants who are in the United States extending, changing status from whatever status they are, they do not have to pay for it. Clearly, the press secretary to the president this afternoon, and I'm going to pull up the press secretary's Caroline Leavitt had stated to be clear that this is not an annual fee. A lot of people were mistaken that this is going to be an annual fee, like every year the employer is going to pay the 100,000 for that particular employee. First of all, it is not at all an annual fee. It's a one-time fee that applies to the petition. And those who are already hold an H-1B visa and are currently outside of the United States, they also will not need to pay the 100,000. So you may say, then who's going to pay this 100,000? They've implemented it and it's going into effect tomorrow at 12 Eastern time. It is going to be for those new petitions, and I'm going to also read out the actual uh, language from the letter, the memorandum that was issued to the Associate Director of the USCIS. And it says the proclamation only applies to prospective petitions that have not yet been filed or in the process of being filed for, through the lottery system. So these are for the first timers if they are filing an H-1B for the first time and they're going through the lottery and they're picked in the lottery and they go for their stamping, then they will be the ones to pay. When I say they, not the employee, but the employer will be the one paying the 100,000 towards that petition. They're not paying for the employee, also they're paying for that particular petition. So to clarify, the people again who are in the United States do not have to pay the 100,000. And also the people, the applicants who traveled out for a short period, whether it is an employer's request or a family reason, they have traveled to their respective home country, they don't have to pay the 100,000. But Kishore Garu, we have been telling everyone, at least I am telling everyone, don't try to rush and come back by tomorrow, September 21st, for two reasons. One, if you're coming back as a returning H-1B, you don't have to pay the 100,000, but the CBP has not yet been educated on this particular implementation of the proclamation. So they don't know who has to pay and who doesn't have to pay. They haven't been given any formal training on this as to how to deal with this. So I have a gut feeling they may make a mistake and either send that individual back to their home country, or they may say, well, you didn't pay, even though that person is not supposed to pay, and place them into removal proceedings. So, which is why I am particularly telling people, do not rush, do not try to come back by September 21st. Let the implementation begin, let the training begin for the CBP so that they understand what they are supposed to do, who is included and who has to pay the 100,000 and who doesn't have to pay the 100,000, who does it apply to and who is excluded. So they need to get this training also, and they haven't been trained because the proclamation was signed on Friday and it's being implemented on a Sunday. So obviously the CBP has not been completely educated about this. And as an attorney, I feel they may make mistakes and either send people back or put them in removal proceedings. So to avoid that, we are telling, as an attorney, I personally and many of my colleagues are advising H-1B applicants who are returning back from their home country if they can stay on for a few more days, wait for all this to, get unraveled and more education is given to the CBP officers so that there are no mistakes committed by them, which can become a very costly mistake for the applicant. So this is definitely something I wanted to first tell everyone if they are trying to rush and come, because I see a lot of blogs where people are advising them come back before the 21st, otherwise you'll end up paying 100,000. So it may not apply to them, and if it doesn't, and if they come and CBP doesn't know about this completely, they can make some goof ups and can put these people into trouble. So if you know of anyone who's trying to come in a rush, also tell them not to rush and come. Let them wait. It is very, very clear from the proclamation, and I'm looking at the memorandum that was issued to the associate director today, and it's clear that the proclamation only applies prospectively to petitions that have not yet been filed. Also, there is a confusion which has not been cleared to us, Kishore Garu. One is people have already filed the petitions for the 2026 fiscal year sometime between April and June. And some people got picked in the second lottery and they've already filed their application. So are they subject to this 100,000. We are not very, very clear on it, but based on the language that I'm reading, if it is a first time petition, I definitely feel that they would be subject to this 100,000. And those are the new petitions. They'll be going for the first time to the US consulate to get a stamping and come into the United States. The same lottery applicants who were picked up in the United States who are going from an F1 OPT or a STEM OPT to an H1, again, are not going to be subject to the 100,000. It's kind of interesting how only the applicants who are outside the United States are being targeted on this 100,000. And like I said, the USCIS portal doesn't even indicate who pays for this, whether it's going to be the employer or the employee. I'm assuming it is going to be the employer, but they haven't given any indication as to where and how the employer is going to pay this money. Is he or she going to pay the whole thing in one go? And, all these things have not yet been clarified by the White House when the proclamation was signed. So I'm pretty sure in the coming days, this is going to be discussed. This is going to be given more clarification. And we are waiting from AILA to get some kind of direction for us as attorneys. AILA means the American Immigration Lawyers Association, are still looking at this proclamation, and we are waiting for some word from them tomorrow or in the next couple of days. So just to clarify again, all those applicants who are in the United States who are filing for any amendments, extensions, change of employer, change of status are not going to be subject to the 100,000 fee. Only the first time filers, prospective petitions that have to be filed are the ones, and especially who are coming from outside the United States, are the ones who are going to be subject to this 100,000 fee. Again, it's a one-time, one petition. This is not an annual fee that somebody is going to pay annually. I don't think any employer will survive if they have to keep paying annually 100,000 per applicant. So this is not something that is going to happen. And a lot of people also had questions, is there going to be any litigation challenging this proclamation? We don't know yet. There may be, I'm sure, the American Civil Liberties Union, and also typically we see the American Immigration Council that does file lawsuits, litigates against the government. Especially in my opinion, the government did not give sufficient time to allow people to understand the proclamation and unravel it, to know who is subject to it, who's not. And it has been implemented in about 48 hours. So I have a feeling that there will be some litigation on those grounds too. So, but we haven't seen anything because this was just the weekend, and I'm expecting there will be some kind of litigation coming up. So I just wanted to bring up all these major points for clarification. Again, this is not an annual fee. This is a one-time fee that applies only to the petition and those who are already in the United States on an H-1B visa and or currently outside the United States on an H-1B visa that was previously granted to them will not be charged the 100,000 to re-enter. H-1B visa holders can leave and re-enter the country to the same extent as they previously used to do, and they're not going to be subject to the 100,000 just because they are re-entering. There was a confusion about this as well. And like I said, the press secretary to the president clarified that it will not apply to those who have traveled out and are coming back on an H1. So This is
Thanks,
something I
Umagara.
just wanted to clarify. And if there's questions, I would be glad to answer any questions that I know and I have knowledge about.
Sure, yeah. Thanks, Umagara, for clarifying all those things. I think that viral
Sure,
video which went where President was signing the proclamation, I think that video also created a lot of confusion because in that video they mentioned that it will be annual, and then yeah, there was a lot of
correct.
renewals also they mentioned it will be. So because of that, I think that created more anxiety or for all the H1 community. But yeah,
Absolutely. I did go back and listen to the video again, and you're right about it. And many people pointed out too that the cabinet person, I'm forgetting his name, he mentioned that this is going to be an annual fee and that the employers will be paying the fee annually. So even though the proclamation does not state that, he brought it up as an annual fee. So I think that created a confusion among the community. So I just wanted to, that's why I read the uh, proclamation with the memorandum to the associate director to the USCIS, and also getting clarification from Caroline Leavitt, who is the press secretary to the president.
yeah, thanks, Umagara. So in case if let us say if someone lost a job who is on H1B and if they are traveling to India
Yeah,
and like after 60 days gap, that means their employer revoked their H1B. And if
right.
they are again they got another job through a different employer. Now again, if they travel back, will that considered as a new petition or it is because they are cap exempt, right? Because already they had
They're still
H1B.
cap exempt. Correct. So they get the 60-day grace period, like you rightly said. Many people are getting laid off due to the job market right now. Let's say somebody is in the 60-day grace period, and let's say on day 59, they find an employer who's willing to do their H1. They can change to that employer on the 59th day, and they're not going to be subject to the additional 100,000 fee.
Okay.
And let's say they go from on the 59th day, they are filing for a B2. And 5 months down the line, they find an employer who's willing to do their H1. And since they are not cap subject, they can still change their status in the United States and they don't have to pay the 100,000 fee. And even if they travel out, get a stamping, and they're re-entering with a re-stamping, they're still not subject to the 100,000.
Okay. Good. That's yeah, that's very good news. So even though they go to F1 or B1, whatever it is, if they want to
Correct.
convert back to H1, this will not be applicable. Cool. Yeah. So if anyone want to ask your questions, Umagaru, as most of you know, Umagaru is more than 30 35 years experienced in immigration in this country. So if anyone want, they can raise their digital hands. I'll unmute them so they can. Yeah, Mr. Raghu, please go ahead.
Yeah. So it might be repetitive. So just wanted to check, what about the extensions or renewals within the US?
They're not subject to the 100,000 additional fee.
Okay. The reason I was asking is the memorandum from the USCIS doesn't clearly or explicitly talk about the renewals. It just says all about new petitions. Uh, so yeah, it's quite conflicting between what the press secretary said and what the USCIS memorandum has in it.
Sure. Like I said, in the coming days, they're going to unravel this proclamation because it was poorly written, not properly written. And I guess, this was done in a rush and they will definitely come about and give more clarification to this. And I'm sure the press secretary would have checked through proper sources, and I'm hoping she has checked through proper sources when she's giving this information out.
Okay. Thank you.
Not at all. And please stay tuned. And I'm pretty sure Kishore Garu is going to organize another webinar, and any further clarifications will bring it out to the community.
Sure.
Mahesh, please go ahead.
Yeah, thank you, Kishore, for arranging this. I have a couple of questions. If the H1 is already picked and they have approved in 2024, but they haven't went for stamping in India, does they subject to this 100,000?
No, because you were picked in the last year's cap. You were subject to the cap in 2024 and you were approved. You just didn't go for a stamping, so that's fine. At the moment, I wouldn't advise anyone to go travel because of all these confusions. I would not advise anyone to travel out at the moment till there is a clear clarification to the consulates as well as to all of us. But I'm pretty sure it will not be considered as a prospectively filed petition, which will be subject to the 100,000. So I'm pretty sure it may not, but Mahesh, I would not travel, whether it's for you, whether it's for your friends. This is a sincere request to all of you. Please, if you do not have to travel, please don't travel.
And can they go for stamping?
I wouldn't go for anything at the moment.
Okay, thank you. And one more thing is...
The reason I'm saying that, Mahesh, and I'll bring it up, which I said that earlier also, CBP is not completely educated on all these aspects of the proclamation.
Okay.
And CBP is being given a free hand to do anything they want at the airport. Now, as you know, we are humans. We can make mistakes. They can make mistakes too. And if they feel like somebody is coming back, even though they're not subject to the 100,000 fee, if they feel like, no, you had to pay and, it is their word against yours, either they can deport that individual back or put them in removal proceedings. So I don't want people to go through this pain and suffering. If they can hold off for the stamping also for some time, I would advise them just to hold off.
Thank you very much. And one of my friend is on H4 visa. Her visa was H1 was picked in 2025 lottery, and they selected for consular process, not the regular one, the consular process. Would they subject it to 100K when they apply for a change of status within the United States?
I believe within the US, or she's outside?
Within the US.
But you said they filed it as consular process.
Yes, they filed the consular process because at the time applying, she was visiting India.
Okay. Is she still visiting India?
No, she is in the United States now.
Well, but they filed it as a consular processing.
That is correct.
Okay, then she may be subject to the 100,000.
Okay.
But even though she's in the US and they have not amended it to reflect that she's in the US and she would be changing her status, I believe she would definitely be subject to the 100,000.
So since it was applied as a consular process, even if her H1 is approved, so you will advise that don't file for change of status so that she will continue on H4. Is that correct?
No, I didn't say that. I just said that since they have filed for her as a consular processing and not a change of status in the United States, she is subject to the 100,000 fee.
Okay.
Because they did not do an H4 to H1 for her. Okay. They've done a consular processing. For why, I don't know that. They should not have done that. It would have been easier to do a change of status here. I don't know why a lot of employers choose this. I've seen this a lot of times, even with students. They ask them to do consular processing and go there and get the visa and come back. It's not the greatest of ideas, even now or even before. But by doing that, especially for this situation, she or he may be subject to the 100,000. But let's wait and see if the USCIS or the White House is going to give us any further clarifications on that.
Okay, thank you so much.
You're welcome.
Vasu, please go ahead.
Thanks, Kishore Numagara. My question is related to I-94 status.
Uh-huh.
The current I-797 is valid till 2027, but visa and
And
passport expire
2027, what is that in
all the
H1? What kind of stuff?
H-1B.
Okay. Okay.
And current visa was expired in last year and passport going to expire in a month. And I'm
Okay.
renewing passport. So do I need
Okay.
to travel back to get it stamped, or I can stay
I
here as
wouldn't
long as
travel back, Vasu. I wouldn't. Please
I
wait
mean,
for all this confusion to be cleared out.
okay. No,
And
I
as
can
you
stay
know,
in US, right?
they have done away with Dropbox also. Those options are also gone. And, everybody has to appear for an interview. So things are going to be more stringent at the moment. So let all this dust settle down a little bit before all of you plan on going for stamping.
Okay, thank you. I mean,
You're welcome.
the further follow-up on this. So we are allowed to stay here as long as H-1B status is valid, right? Without getting
Correct.
stamped.
As long as your approval notice, which has the I-94, is valid, you can stay here. Your employer can either file for an extension if you're eligible for that, or you can always change your status based on today's rule, change your status either to a B2 or to an F1.
Okay, thank you.
Vikas, please go ahead.
Yeah, hi. Thank you for taking my call. So I have four things which are contradicting each other. Okay.
Okay.
First thing is the DHS, not the DHS. First thing is the White House proclamation order, which clearly says the headline says restriction for entry. Okay. So it clearly says who is going to enter. Okay. Second is White House press secretary. She gave some clarification on Twitter. So not sure it's an official way to give some instructions or a clarification. So where she has mentioned the change will only impact 2026 folks who will apply for lottery, no impact on existing visa holders, and no issues in amendments, extension, change of transfer, okay, change of status and all. Okay, second. Third is DHS has published a memo where they have mentioned that USCIS will process this, will go through this, will take this proclamation in effect, and they will not handle or approve or adjudicate any petitions for the aliens. So listen to the word, which is very important. Adjudicate any petitions for the aliens outside US. Okay. Now, the fourth memo is from the USCIS. So USCIS have not mentioned anything about the adjudication of petition outside US. They have simply mentioned this proclamation is applicable for all the petitions which will be filed after 21st of September 1201. Okay. So four documents, four statements, and the interpretation is different. Means not the interpretation means like the outcome is same, because when we check with Grok, ChatGPT and all, so it is giving different information. Okay, so my question is like, what is right and which one should be followed? Because if people who are in US and they have extensions, amendment, change of status, or transfer, planned for. Okay, so what will be the impact in this case? Because like people who have planned for their amendment extension, whose I-94 is going to expire soon in a week or 10 days, in those cases, right? How the strategy will be followed, or what needs to be done and which one needs to be followed? DHS, USCIS, and like press secretary information or the White House proclamation. So four different documents within 24 hours giving different information, which is giving lot of confusion and which impacts the the strategy and plan for the people. Yeah, thank you.
Well, it's too early to plan anything at the moment. You'll have to give this proclamation was barely signed on Friday, and we are here on Saturday. So we are also planning things way too early. Don't you think so? So we need to give it a little time, as I said, for it to get unraveled. It has not been written very clearly. But the USCIS is going to be the one to come out and say, this applies to these people, this doesn't apply to these people. These are the ones to pay. Where are you going to pay? When are you going to pay? Who doesn't have to pay? Who is excluded? They haven't even come and clarified about nonprofits. They've clarified that H-1B ones, which are coming out of Singapore, this 100,000 doesn't apply to them. They've clarified that, but they haven't clarified a lot of things. Okay. So we need to give them some time to run this. We are barely about 24 hours into this.
Yeah,
And
but the
I think
problem.
I think we are also jumping the gun pretty quickly
Mhm.
because people are just blogging, people are writing anything they want to.
Yeah.
This is what it is, this is what it is. And like you just said, you use chat GPT or AI, whatever, to interpret the proclamation, and that would not be the right way to do that. I'm not trying to condemn you or your actions. I'm just saying
Yeah,
we are jumping the gun a bit too early. If you clearly read the memo that was given by the USCIS, the memo, it clearly says the proclamation does not apply to aliens who are the beneficiaries of petitions that were filed prior to the effective date of the proclamation. So they are clarifying that in the memo.
So what about the extensions, amendment, transfer, and change of status?
They've clearly said it doesn't apply to them, but they will come out in the next few days and clarify it.
Okay, because every petition, every application is considered as an independent petition, right?
Not really. If you're already on an H1, now you can go from one employer to another, right? You're not subject to the cap, right?
Okay.
You don't go through the cap, right? You're not cap subject.
Yeah, correct. So my understanding is
that is the same philosophy they're applying to that, saying you've already been on an H1. You're already in the United States. So if you go from employer A to B also, you don't pay that. Or if your employer A is extending your H1, you have an I-140, they're going to extend it indefinitely. You don't pay that.
Sure. Thank you so much. Really appreciate. Thank you, team, for having this.
But I want all of you, not just you, because every one of us, whether it's me, you, or anyone, let's all not jump the gun. Let's all give it a little time so that, this can be unraveled even more carefully. We are jumping the gun and we are coming up with our own analysis by, reading blogs. Somebody's even putting up tables saying this is right, this is wrong. And I'm not condemning them. Everyone is trying to do their best. Nobody wants to hurt anybody. The intent is not that. But even if we are trying to do it the right way, if we don't know how to interpret it, we could be doing the wrong things. So that's why I say, let's give them a little bit time. At least let's wait till Monday. And let's wait for the government to come back and say, this doesn't apply, this is wrong, or the press secretary was wrong, she's, completely wrong, she didn't read it properly. Let them come and say that. Okay, we'll get a clarification, right?
Thank you so much. Thank you.
You're most welcome.
Ashish, please go ahead.
Yeah, first of all, thank you, Mrs. Uma and Kishore, to arranging this.
You know what? We should give this credit to Kishore Garu. He jumped in. He called me at 7:30 this morning saying, Uma Garu, can you spare some time and do this? And he always comes through for the community. So
absolutely,
you guys should all thank Kishore.
No, thanks, both of you. So, as you're saying, we need to give some time to unravel this. What is that specific time? If we are planning,
I would say just a couple of days. I would say maybe like 2 or 3 days.
2 or 3 days.
I'm a member of the American Immigration Lawyers Association, and we've always seen that American Immigration, AILA, as we call that, they come and clarify all this to us.
Okay.
If
So
they
if you're
have any questions, what
Mhm.
they do is they go back to the White House to get clarification, saying, hey, you said this, but they said this, and somebody else said this. What is exactly the meaning of this proclamation?
Okay.
They
Most of
usually try
Mhm.
to get this clarified,
Yeah.
and they give us a clarification. And like I said, right now, this was signed on Friday evening, right?
Mhm.
Saturday, Sunday, nobody is educated the CBP.
Right.
CBP
So
doesn't even know what's going on.
yeah. So if most of us will be planning travel during the Christmas time, so that time should be fine. In it.
I would hope so, Ashish, but I wouldn't make plans right away.
Mm.
Please wait. Uh, we are going through a roller coaster right now.
Right.
Okay. So this is not the best time to plan anything to go out of the country for Christmas, whether it's to India or to Switzerland or to
Mhm.
Paris. I would hold off.
Okay.
I know
Thank you
it
so much.
can sound disappointing to you and to your family, to your children, but it's better to be careful than to be sorry later. Let's
Absolutely.
wait for them to unravel this, and we don't know what else is in storage for all of us. I hope
Mhm.
nothing more than this. I'm keeping my fingers crossed, but let's keep them a little bit of time.
Okay.
Is my
Thank you.
request.
Thank you
Okay,
so much.
you're welcome.
Mr. Gandhi is good.
Yeah, thank you, Kishore Garu, for arranging this. My question is related to travel. Is it safe? Again, I'm asking for my brother's family. Is it safe for my brother's family to travel internationally right now to resolve an I-94 issue? Um,
What
so
is
my
the
brother,
I-94 issue? If you can tell me that.
yes, yeah, my brother is on H-1B visa and his family has valid visa stamped until Jan 2026. While preparing for his extension now, they discovered that his child I-94 was only issued up to passport expiration date uh, during their last entry. They issued I-94 only until passport expiry date, which was
And
December
when
of
was that? Until December of 2024?
yes, and they
And when
realized
did they realize that? Just now?
yes.
Okay.
So they are now exploring options to extend the child stay. Some have suggested traveling abroad and re-entering so that CBP officer can issue a new I-94 with the correct validity date. But because of these things, is it safe to travel now, or are there any other safer ways to correct this from the US itself?
First of all, this 100,000 has nothing to do with the H4 dependents. So, having clarified that, they will not be subject to anything to do with the 100,000 part of it. Okay. Now, as far as correcting the I-94 issue, which was an oversight by whoever had an oversight, sometimes we do something called as a non-pro-tunc. It's telling the USCIS it was an honest mistake, it was an oversight, or maybe the attorney didn't warn us. These days, you don't even get I-94s. You'll have to go online and check it out. So wherever the mistake happened, they can tell them that this was a mistake. And if they can, especially with for a minor child, they may overlook that and still grant them a non-pro-tunc. A non-pro-tunc helps in these aspects. Now, I don't know what will happen when they go to the consulate. Anytime you have 180 days or more overstay, typically there's a 3-year bar. But since this is again a child, a minor, I don't know if the consulate will put those bars on the child. Pretty much they should not. But again, given today's conditions, I won't, I won't put past what they will do. They can give 221Gs, keep them there for the longest period of time. They can do anything at this point in time. So if you don't want them to be separated from the father, the family, I would just do a non-pro-tunc and not travel out of the country.
Yeah, thank you.
Okay.
Umar, please go ahead.
Hey, thanks Kishore Garu for arranging this session, and Thank you, Magaru, for answering very patiently
Welcome.
for everyone. My question is, if a individual who is on STEM OPT and has been picked up for H-1B for 2026, and they are waiting on their petition uh, approval or rejected status, should they be concerned about this proclamation at all?
Are they in the United States?
Yes, they're
No, they
currently in
don't have to. They don't have to be, based on the clarification again by Caroline Levitt. I'm just going by the press secretary's clarification, and also my interpretation of the memorandum from the associate director from USCIS. Doesn't appear that it will affect anybody who's here on a F1 OPT, STEM OPT going to an H1.
Okay, and my follow-up question, I know it's for my spouse, and it's a change of status. However, my friends who have applied might have applied for consular process who are on STEM OPT, and are they be in trouble?
They're not in trouble, but if they are doing consular processing, they possibly will be subject to the 100,000 fee.
Okay, because they might have to go back to the country and have
consulate.
to come as
Get
a
it? They're
new
coming in
H-1B
for the
candidate.
first time. It's a new petition, first time. So
Yeah, that
they
makes
could
sense.
be, based on the language, they could be subject to the 100,000.
Okay, thanks for the awareness. Thank you so much.
You're welcome.
Afsar Sheikh, please go ahead.
Yeah, thank you so much, Kishore, for organizing this, and Umagaru. My
Welcome.
question is actually on behalf of my brother, who is currently in India. His petition got approved last year with the last year quota, and
Which is for the
but
H-1B?
for the H-1B, yes.
Okay.
But he didn't go for the interview yet. So he was planning to appear for the interview later this month. Will there be any impact to his his situation, his thing because of
Again,
this?
reading the memorandum from the USCIS, I don't think the 100,000 would apply to him. But again, I would wait on getting more clarification to that.
Okay,
Because
sounds
he's
good.
still a first-time applicant for the stamping, even though his H-1B was picked up a year ago, 2 years ago, but he just did not go to the consulate for a stamping.
Yeah, I saw the tweet from the secretary that this will apply for the next year cap, starting from the next year cap. But again, there is still ambiguity on that, I believe.
Correct.
So just wanted to get clarified on that. Thank you so much, ma'am. Appreciate that.
You're welcome. And I am pretty sure we are going to get a good amount of clarification this coming week, starting Monday, Tuesday. We are looking to see that we will get some clarifications from AILA, the American Immigration Council. All of these organizations will give us some direction so that we can give you a better direction.
Sounds good. Thank you so much, ma'am.
You're welcome.
Sunil, please go ahead. Sunil, are you there?
Yes. Yes, Kishore. Thank you so much.
Hi, good evening. Thank you, first of all, for this opportunity today to discuss.
You're welcome.
Yeah. So my concern is I have a H-1B for 3 years now. And last month, I completed my project with my employer.
You completed what, ma'am? Sorry.
I completed my project with my employer.
Okay.
And I got a new project now.
Okay.
So I'll have to change my employer for that.
What do you mean? You mean you got laid off with your previous employer?
No, previous one I had a contract, so that got completed. After which, the previous employer was unable to find one project for me. I got it through another employer now. So
That's what I'm saying. So you're done with employer A, you're going to employer
B. Yes.
Okay.
So in this process, during the search process, I came to Canada to meet my family over here.
Okay.
And my stamping is not done yet, but I have a valid I-797.
Okay.
Yeah.
But
So
your country of birth is Canada or India?
India.
With the new, rules that the State Department has issued, I don't think they will allow you to do a third country processing of the H-1B. They may ask you to go back to your home country.
Okay.
Have you heard of that?
So there are many friends of mine who have got the stamping done in Canada and they've gone. But my concern is now if I get the stamping done here, would this new proclamation be implemented in my case?
No.
Oh,
As per what I'm reading, the answer is no. But I'm more concerned that I don't know if Canada will give you the stamp.
Oh, okay. Because I have few friends who got H1 in US itself. They came on H4 and they got their lottery in H1 and they got their stamping here in Toronto.
When was that?
Yeah.
When was that?
Oh, when
How
was
long
that?
ago?
That was recent, I guess, in March.
Okay.
Yeah.
Things have changed since March.
Oh,
That's why
okay.
I asked that question. People always tend to do this, compare, what happened in the past.
Oh, okay.
Recently, the State Department has announced that they will not allow people to go to a third country and get their H-1B stamping. They will have to go back to their home country.
Oh, okay. So I have to go to India to get my first H-1B stamping and then I can go back
Correct.
to.
Correct.
Oh,
But you can check with the US consulate in Canada just to confirm.
okay. Sure, ma'am.
All right. Okay. All the best.
Thank you very much. Have a good rest of your evening.
Thank you.
Ms. Mantravadi, this is Dr. Shrestha. Thank you for taking the call. And Kishore, thank you
You're
for
most
arranging
welcome,
it.
sir.
Very good conference. I'm a doctor. We have a lot of foreign IMGs that come over. I actually help a lot of them come over to the US. Is this going to be applicable at all to any of these people? We are minus 120,000 doctors in the US. So how is it going to affect these guys? A lot of them are.
Well, most of the doctors that I know typically come on J1s.
Right.
So it does not affect the J1s.
Okay. But some of them are on these H1s.
Right.
What
If they've already got the H1 and they're already working with you or whichever organization they're working for in the United States, it's not going to affect them, even if they do an extension.
Okay. So doctors are exempt.
I'm not saying that. I said that even if they're a doctor, they're on an H1, and if they've already, been approved of an H1 from a J1,
yes,
of course they'll have to get a waiver of the J1 and then go into an H1.
Yes.
And once they do that, they've already been approved of an H1 previously.
Yes.
This 100,000 is not going to affect them, even when they do the extension or amendment or change of employer.
Okay. Thank you so much. Appreciate it.
You're most welcome, sir. Most welcome.
Babu, please go ahead.
Yeah, hi. This is for my friend. And first of all, thank you, Kishore Garu and Oma, for your help and for the community.
Most welcome. Most
The
welcome.
the question is because of this 100K proclamation, there is a chance that like existing, H1 candidates will be porting to EB1C, and I think I heard EB1 also going to be removed and with the EB5 visa that they have signed in addition to this 100K proclamation, right? What is your view? Basically, the porting will be more to the EB1C because of this rule, are like how because recently date of filing is advanced 15 months, right, for the B1C, but final action date is still remains same, and this is this is kind of confusing. Like what do you think the reason behind of this, and how is the future for that porting for EB1C?
No, actually, a lot of people have been jumping to L1, working out of the country, whether it's going back to their home country or some other country, working for an affiliate or a parent company and coming back on L1. because people have been, waiting in line in the EB2, EB3s, and they were fed up. And a lot of them didn't qualify for the EB1 A or B as outstanding researchers or professors or outstanding in their field. So EB1 A and B was not an option. Then EBC coming in as a multinational manager was the best option. And they could port their EB2, EB3 date to the EB1 and get a green card much faster. And this didn't come out just because of the proclamation. But what you said is correct, is what I've heard as well, that there is an intent on the part of the Trump administration to eliminate EB1, EB2, EB3. They only want to keep EB5, and they've even, somewhere I've read this, where the president had stated that they want to bring people only with a $1 million investment. They only want the rich and the richer. Even though the president has always said they want the brightest people in this country, especially people with STEMs and all that. But we've suddenly heard a different rhetoric, which is saying we want the rich and the richest in this country.
Okay. But porting because of this 100K, the porting.
It's not because of the 100K.
Okay.
It's because they want to just get the green card faster. Because people are stuck in the EB2, EB3.
Yeah. In addition to that, maybe this is adding more, porters, right?
Not really. It's always been that the EB1 is at 2022 right now, the final action date. And I believe the filing dates are at 2013. So it gives a better chance for people to get their work permits, travel permits, things like that.
Okay. What is the reason for date of filing with 2023 for EB1C, but final action date is 2022 still?
Because they don't have visas. They allow you to file to allow you to get a work permit and a travel permit, but they cannot issue the green cards because they don't have any visas available. The State Department is the one who tells how much of visas are available in an EB1, EB2, EB3 for each country. And if the visas are gone, the dates cannot move forward.
Okay. Thank you very much.
You're welcome.
Umaga, there are a few questions in the chat. I'll go through them.
Sure.
So I have a visa stamping on my old passport that expires in April 2026. Okay. And also same with my I-94 validity, though the visa stamping is valid till July 2027. Can I travel and re-enter to extend the I-94 validity?
And the I-94 is valid till when, Kishore Garu? Sorry.
Until April 2026.
And the visa stamp is valid till
July 2027, right?
Yeah. They will give him the I-94 validity date only till when the H1 is valid only. They won't give it just because the stamping is for a longer period.
But is he okay to travel?
Yeah, he can travel. Yeah. As per this clarification at the moment, yes.
What about the F1 students currently in the US who will apply for H-1B in the lottery next year? Will they be subject to 100K?
Not in the US as per this proclamation and the memorandum from the USCIS. Now, again, we'll have to wait and see what the USCIS is going to come and tell us in the next few days, Kishore.
My H-1B got picked this year and approved. My status changes next month. Will I be affected?
No, you will not be.
I am on STEM OPT, and next year, if my H1 gets picked while I'm already staying in US, will my employer be charged 100K?
Not as per this proclamation. We don't know what will happen next year. So, let's hope for the best, that they don't do any changes.
Do you recommend or suggest to bump the existing pending 2026 H1B petitions change of status to premium?
I always prefer doing it in premium as an attorney, Kishore Garu, because sometimes the regular processing can take months and months and months. And, it can be very frustrating both for the employer and employee. So I always recommend doing a premium processing. So they can always upgrade it now from regular to premium.
Yeah, thanks, Umagaru. I know you had a personal event. You are in a
Sorry,
sari, but
sorry,
still,
I'm wearing a sari. I didn't get time to change up, Kishore Garu, and I'm
no
sorry to
problem.
all of you.
That shows your service-oriented nature. Right, yeah, yeah, even though you are in a personal function,
It's okay.
you took time to help our community. Thanks a lot for that. And
Most
yeah, we'll
welcome,
be doing
Kishore.
more of these webinars with Umagaru every 2 weeks.
Yes,
And if Umagaru gets any more updates from our clients who are
yes,
traveling or anything, we may do something within next 2 days to give you all the
absolutely.
latest updates. So,
Anytime I'm available to do this for the community, Kishore Garu, it gives me a lot of pleasure that we are able to do something for our own people. And doesn't matter which part of the world they are from, as long as we can help our community. And I know H-1Bs are predominantly coming from India. There's been a statistics that was distributed that 71% of H1s are from India. So all this is affecting us, and definitely, as soon as I get any information, I'll reach out to you, Kishore Garu, and let's do another webinar for our community.
Umagaru, thank you very much. Yeah,
Again, I'm very sorry for coming in this sari.
yeah,
Didn't
no
intend
problem.
to, but I
Yeah,
had to just jump in. I didn't get enough time to change up. So,
yeah, no problem at all. And
okay.
yeah, don't worry, everyone. Everything will be fine. So, as Umagaru clarified,
Yes.
it won't impact anyone who are already here. Also for renewals, extensions, mostly it will be only for the new petitions. So, yeah.
And again, my sincere last advice, please don't travel if you don't have to travel. Please stay put till we get some clarifications on all of this.
Yeah.
All right. Thank you so much, Andy. Have a
Yeah.
good night.
Have a nice rest of the weekend and good night, everyone.